Number 90, matter of Madeiros versus New York State Education Department. Counsel?
Good afternoon, Your Honors. May it please the Court, Cynthia Neidl for FOIL petitioner Pamela Madeiros. May I reserve 2 minutes for rebuttal?
You may.
Thank you. This appeal raises several important issues concerning the interpretation of the law enforcement exemption under FOIL and the application of that exemption to agency audit procedures used in conducting routine fiscal audits. In affirming nondisclosure, the courts below broadly construed the law enforcement exemption in favor of nondisclosure and conflated subparts 1 and 4 of the exemption. The decisions conflict with well-established principles frequently cited by this court, including that FOIL exemptions are to be narrowly construed. The agency has the burden of demonstrating that the records fall squarely within an exemption, and the agency must articulate a particularized and specific justification for nondisclosure.
Would you agree that substantively what we have to decide, there may be some other issues, but here is first whether the records were compiled for law enforcement purposes, and then second whether either subdivision 1 or subdivision 4 apply, correct?
Exactly.
Okay. So I want to start with asking you about what compiled for law enforcement purposes means. And I guess stack it a little bit with, it seems to me that the federal, under federal law, that encompasses civil and regulatory law enforcement. Our Committee on Open Government has opined that it is that broad, and as I look at the statute as a whole, you know, we have some provisions that refer explicitly to criminal investigations and others that don't, and of course that general provision doesn't. So do you agree that this at least falls within that broad category, and if not, why not?
Well, we don't take the position that it only applies to criminal proceedings, but it compiled for law enforcement purposes is a term of art, and law enforcement purposes, as the ordinary person would understand that, is some sort of enforcement proceeding. Agencies every day
Well, for the
go about
purpose of
enforcing.
making sure that people are complying with the law.
Well, I think all agencies do that as a matter of course in everything that they do. I think if you were just to say, as the third department did, that the agency compiled it with law enforcement purposes in mind, I would submit that every record within every agency is probably compiled for law enforcement purposes, because agencies are acting with law enforcement in mind.
So
I think
have you
something more.
taken a look at the Greenberg-Traurig website for the client advisory written by Ms. Madeiros that says a law was enacted in 2013 directing the New York State Office of the State Comptroller to audit the expenses of every program provider of special education services. The Comptroller is also directed to refer any findings of fraud, abuse, or other conduct constituting a crime to the appropriate agency, including the district attorney. So she has a view that there's some law enforcement purpose involved here, no?
Well, I think that we have to distinguish between the comptroller's audits and the audits at issue in this proceeding. I know the line is blurred by the state's brief, but the comptroller's audits are not at issue here. I can't say what those audits contain, and maybe if the comptroller were foiled and that case came to this court or the lower courts, the comptroller would be able to justify withholding. But in this case, we are talking about municipalities who are performing the audits. They have no obligation, and they are not directed by either the legislature or SED to refer.
Isn't the concern rooting out waste and fraud and abuse by service providers?
Well, I think the record doesn't reflect that. The record reflects that they are going in to determine whether the various programs complied with various policies, but it's very different from a targeted investigation where there's a belief that there is some sort of fraud.
Well,
This is a first
that
step.
analysis may go to the subdivision little I exemption, but I'm not sure that it's that focused in the compiled for law enforcement purposes. And it seems to me, in response to your earlier statement, that there are lots of records of state agencies that would have to do with protecting the public and different things that have nothing to do with rooting out fraud and that sort of thing, which appears to me from the legislative history that is what this legislation was intended to.
Well, I think that, again, the line is blurred between what the comptroller is doing as part of his audits and what the agencies are
Well,
doing.
I'm talking about the legislation that was encouraging the municipalities, giving the municipalities, the amendments, giving them more of a stake in it, more of a financial stake in it, and that the purpose of that was because they were finding that there was more fraud, and they were looking to root that
Well,
out.
that might have been the purpose of the legislation, but the statute is, how were the records compiled? Were they compiled for law enforcement purposes? And I guess what you're saying is...
Seems like you're trying to draw a distinction, excuse me, between regulatory audits and law enforcement audits. It seems that they're trying to, but that doesn't seem to be what the case law says. The tough case for you is that Fink versus Lefkowitz. I'm sure you're familiar with it. You want to address it?
Oh, sure, I would love to address it, and I don't think it is a tough case.
Well, there you go. There you go.
In
Go
that
ahead,
case, in that case, the agency was a special prosecutor charged with criminal investigations. It involved an investigative manual, not merely audit procedures. The manual is compiled by the special prosecutor to be used in the context of criminal investigations. In that case, only subpart 4 was involved. That doesn't get to the compiled issue, but it only involved subpart 4. And subpart 4 was held applicable to criminal investigatory procedures, not routine audit procedures, which is what we have here. The court upheld nondisclosure of detailed, specialized methods of conducting a criminal investigation and factors that would alert an investigator that something is awry. I don't think we have that here.
Well, what if you had here here you had a blanket denial, right?
We did.
Yeah.
Yes.
But eventually, there were some materials released. I guess there are 5 documents in play, and some were released. Is that right?
There were 55 responsive documents. All were subsequently produced after we brought suit, and only less than half of which had redactions.
I see.
Ms.
So-
Neidl, oh,
Go
excuse me,
ahead,
Judge.
Judge.
No, go ahead.
No, so I'm asking you, if there had not been a blanket denial originally, would we be here?
Had there not been a blanket denial, and I'm sorry, had they produced all 55 documents?
Well,
but
some
with
version of
redactions?
it, and it'd been, usually these are product of negotiation, because I think of that Aguilera case, and I want both parties to kind of comment on that. I'm not sure if I'm saying the name correctly, where the standard set in a criminal investigation, it's relatively narrow. It has to be evidence that's reasonably calculated to uncover information for use in a criminal investigation. It's kind of, they call it the Genesis rule. Here, I think the blanket denial may or may not have led to this kind of litigation, and there may not be a rational solution to the problem. So go ahead, comment on it then.
Well, what was withheld were the standards of SED, which this SED has never argued were exempt, and all of it that are issue at this point are these audit procedures that are not criminal. They are routine audit procedures. And I'm not sure if they had just made certain redaction and produced everything, whether the suit would have been
I'm
brought.
not really, I guess the focus of this, well, your argument before was that it can't be compiled for law enforcement purposes because they're routine audits, but I don't really understand that argument. Can't a routine audit be also part of a law enforcement
Absolutely,
procedure?
absolutely, yes.
Why
I
is
think
that not the case here?
Well, I don't know if I made that argument that because they're routine audit procedures. I would like the court to look at how they were compiled. That is what the statute directs. They were compiled by SED as part of its routine oversight. It has directed that municipalities submit its audits so that it could approve them. That is why SED has them. It wasn't doing it in the context of any enforcement proceeding or in part of any investigation. So that's with respect to the first and the fourth prong, I would submit that because they are routine audit procedures, they don't fit under number 4.
But what's the purpose of a routine audit procedure? Isn't it to, well, there may be multiple purposes, but isn't one of them to root out fraud?
Well, I think if you look at the record, there's no evidence of that in this case. They did not submit an affidavit from an auditor or an accountant, and there's nothing in the affidavit that was submitted that suggests that that was the purpose of.
But isn't that inherent in doing an audit? Isn't that what you're trying to do?
Regulators do audits all the time. Many state agencies do audits all the time. They are not investigations, and they are ensuring compliance with whatever regulatory scheme it is.
These audits have in the past surfaced this fraud. Isn't it clear
That's
then that
inaccurate.
that's what's going on here?
The comptroller's audits have revealed that. There is no evidence
I
that
guess
any
what I'm saying is I understand the comptroller's audits have revealed that, but the fact that you then have the benefit from the government's perspective of routine audits from which you can draw that data, why does that then not permit them to argue that it falls under E?
I'm sorry.
The fact that they
FOIA?
certainly could find out this information through a controller's audit, but they have another mechanism by which to get this information. Why then doesn't it fall within the category of audits, information compiled for law enforcement purposes?
I think if we put aside whether the documents were compiled for law enforcement purposes, we would get to subpart 1 and 4. And subpart 4, for the first time, was raised on appeal, but subpart 4 governs criminal procedures. These are clearly not criminal procedures. So the one exemption that was invoked was subpart 1, and the argument is that because these are techniques, if disclosed, would interfere with audits.
Isn't it possible that a technique or procedure that's used in a civil context can indeed be part of criminal investigative techniques or procedures, just because a technique, here an audit, and however they're doing these audits, are ones that are also used in the civil context? Does
think
that
that-
exclude them?
Well, no, I would think that the term criminal has meaning, though. And so in this context, I would submit that there could be a very different case where there's audit procedures that are regulatory in nature, where they're targeted at a specific entity, that those could constitute criminal procedures. But that's not this case. These are routine procedures used for a number of entities. There's nothing in the record that suggests that they were intended to ferret out fraud or any sort of financial misconduct. I would submit that they are not criminal in this case.
Thank you, Ms. Nadel.
Thank you.
Counsel?
Good afternoon, Your Honors. Jeffrey Lang on behalf of Respondent. A provider of these special education services that was defrauding the state would want exactly what the techniques here give you, which is a precise roadmap.
That may be the case, but what we're looking at is how the statute is drafted, and it does seem, well, first of all, let me ask you, are you arguing, I know the appellate division worked in subdivision 4, are you arguing that? Is that?
We are, yes.
And why should we entertain that argument if you didn't argue that below?
Well, no, we did argue it below. What we said in our initial FOIL response was that if we were to disclose this information, it would interfere with the investigations of compliance.
You never used the word criminal.
Well, we did in this sense, which is that once the Article 78 proceeding was brought, we have always, the department has always taken the position that these techniques are protected, and they would interfere with investigations precisely because they represent specialized non-routine techniques, and similar audits by the comptroller of the very same industry have resulted in criminal referrals. And the point,
isn't there a conflating of subdivision 1 and subdivision 4 going on here? Because let's just start with the criminal investigation. How is this a criminal investigation?
well, it's not a criminal investigation. What we have argued is that these are compiled for law enforcement purposes, and they will interfere with ongoing law enforcement investigations. Those are the fiscal audits.
If your interpretation is correct, why do you need subdivision 4? Wouldn't that all be encompassed under the general E subdivision 1? Does it?
We think the audit techniques are protected both under subdivision 1 and under
What
subdivision 4.
would be the purpose of subdivision 4? Why would you ever, wouldn't it be completely superfluous?
No, because I think the legislature wanted to protect investigative techniques under both. But what subdivision 4 does is it makes explicit what's implicit in subdivision 1 by emphasizing that criminal investigative techniques are covered, and it also ensures
If that was the intention, then they could just say, they could lump it all in one and say criminal, civil, and regulatory.
Well, 1 is general, 4 is just more specific. 4 also ensures that when you have criminal investigative techniques and any investigations using those techniques have concluded, that the criminal investigative techniques are still protected because there's no
Right, so
time
you're
limit.
saying Romanet 4 has an exclusion to the exclusion, which is these routine techniques and procedures.
Right, so it's,
And that's in part not only Romanet 4 is specific to criminal investigation and procedures, but it includes an exception to the exception, which you wouldn't necessarily collapse and put in Romanet 1.
right. I mean, so 4 is non-routine criminal investigative techniques, and as Your Honor suggested, these are not criminal investigations. These are civil audits. They have a purpose to root out fraud. That's a valid law enforcement purpose. Similar audits by the comptroller of the same industry, which had a pattern of rampant fraud and caused the legislature to amend the education law in 2013 to strengthen these municipal audits as well as the comptroller's audits. So those have led to a pattern of fraud, and because the purpose is to detect fraud, they are criminal investigative techniques. In other words, the techniques that, let's say, the auditors were using in the Fink versus Lefkowitz case, they're the same auditing techniques. I mean, they're both using materiality thresholds to select certain expenses to look at. Of course, at the granular level,
Your
they're
point
always
is
going to
to
be
what
different.
end, right? To what purpose?
Right, and the purpose here, there are multiple purposes. The purpose is, again, to root out fraud in an industry that's been plagued with fraud, but also, you know, it could be to bring if there's no evidence of criminal intent, even though there's a expense that can't be substantiated, there could be a civil proceeding, there could be a judicial proceeding, a lawsuit by the Attorney General to recoup
Reactions,
monies.
Yes. Let me ask you this. Does your reading devolve to every piece of data that an agency collects is now not foilable?
Not at all, Your Honor.
Okay, so where's your line? I understand the line she's trying to draw. Where's your line then?
Our line is that when you have a focused and systematic attempt to verify compliance with the law, as you have with an audit, when you're auditing the use of public monies, that clearly falls on the line of being compiled for law enforcement purposes. And if you were to release those techniques, like if you were to release, for example, materiality thresholds, you would be giving the providers the combination to the safe.
So how would you
Agencies-
draw a distinction between evidence or an audit that produces material that's reasonably calculated to result in a criminal investigation as opposed to an audit that's reasonably calculated to result in a regulatory action or perhaps a civil lawsuit? How would you draw those distinctions?
Well, I would think a fiscal audit is a type of audit where you're verifying expenses and expenses of public funds, that falls on the law enforcement side. But, you know, state agencies collect all kinds of information on an ad
Right,
hoc.
but I'm just, for our purposes, how do we draw this line? Because if we can't draw a distinction between criminal, regulatory, and civil in some audit practices, then it seems we have to either say everything could result in criminal or everything's open.
Well, Your Honor, I just want to
Those aren't the choices that I think the court would want to make, so how do we
and
draw the line?
I want to be clear that there's two potentially different questions. One is that are these audits collected for law enforcement purposes? That does not require that they result in any type of crime. There is such a thing as civil and regulatory law enforcement, and so they're compiled for law enforcement
That's fine,
purposes.
but tell me how you draw the line between the civil, the regulatory, and the criminal.
But civil and regulatory purposes would count under the statute because it's compiled for law enforcement purposes. The way I would draw the line between subpart 4, which is a criminal investigative technique, is that if you have had a technique that is designed to produce information for use in a criminal investigation or a criminal prosecution, that is a criminal investigative technique. For example, background checks on persons who are applying for jobs. There are probably techniques that, state police or investigators look at in order to determine whether or not someone is, correctly saying who they are and have done who they say they are. That would not be a criminal investigative technique, because the chances that anything like that would result in a criminal investigation are so remote that, theoretically it could happen, but it's a remote chance. Whereas when you have a fiscal audit that is trying to verify the expenditure of public funds that are claimed by providers, then that is a criminal investigative technique. The same
But
types
I think
of...
what Judge Fahey's trying to get at is, what's the test that you would articulate for putting one in that category and one not in the other? Because it's not just, when it's law enforcement when you see it.
Well, the test for a criminal investigative technique is a technique...
I'm not asking for a criminal
Okay.
investigative technique. I'm trying to get at what you're calling the civil and regulatory law enforcement purposes,
A civil and regulatory...
or audits for law enforcement purposes.
Sure, is a technique that represents a systematic and focused examination or investigation of whether a party is complying with the law. And that's exactly what these
You know,
fiscal...
see,
But isn't that what every audit is?
And I would think that many financial audits serve multiple law enforcement purposes, and so they are audit techniques, financial fiscal audit techniques, I believe, are techniques that are compiled for law enforcement purposes. They serve multiple law enforcement purposes. And I believe that's buttressed.
Yes, I get your point about the fiscal, but you get into this difficulty of separating one type of audit from another. I thought your argument was really that all audits fit under FOIL, but all data collection does not fit under this exception.
That's precisely my argument, yes. All types of ad hoc data collection by agencies, not necessarily for a law enforcement purpose, even though something could conceivably happen. A much more systematic and focused attempt to verify compliance with the law
I'm
is for...
having a hard time understanding why not every audit, whether it's by a municipality ad hoc, whether it's by the controller, it doesn't matter who it's by, doesn't have dual purposes. So it might be ultimately to root out fraud, or it might just be to preserve the public fisc. So how do we tell the difference? I think
Those are
that's
both
the
law
question.
enforcement purposes, Your Honor. And so I believe that even if they have dual purposes, and that's not, my argument is, yes, fiscal audits have multiple purposes.
Okay, let's say we agree with you on that. If we can move into the particular exemptions, how is that interference with a law enforcement investigation? How do we know at what point there's really an investigation, not some potential speculative possible investigation?
Because the two things, one, it's interfere with investigations or judicial proceedings. It will interfere, the fiscal audits themselves are a type of investigation, which is a systematic inquiry into the truth of certain facts. They fit the definition of an investigation. If you look at the Onondaga County's description of its audit plan, and that's in the record at 75,
So ultimately, what you're saying is that this whole section should be broadly read when we're talking about public audits of any type. Anything that reveals how those audits are conducted is safe from public disclosure.
I would say read in accordance with the natural meaning of the language.
But doesn't that conflict with what we're supposed to do, which is to read the exemptions narrowly?
No, Your Honor, I believe that you're supposed to read them narrowly, but in accordance with their natural meaning. And the natural meaning here is that if you have non-routine audit techniques where you have the type of audit that is aimed at verifying compliance with the law, when you're talking about the expenditure of public funds in an industry that has a history of fraud, that those types of investigative audit techniques, that fits within the natural meaning of the statute. Because if you give the providers the audit techniques here, then you are giving them the combination to the safe. If you gave them the materiality thresholds, they would be able to structure their expenses so as to come under any limit, and because they would know what the auditors are looking for in advance.
Because your light is off, and with the Chief Judge's permission, if I could just clarify my last point. So am I understanding you correctly that you're saying audits fit within E, fiscal audits in particular would fit within E Romanet 1, but would still be subject to this narrowing that those fiscal, revealing the fiscal audits or data that collected under the fiscal audits or the procedure interferes with the enforcement investigation. So you've got multiple layers.
Yes.
Even if audits appear on their face, from your argument, to fit within this exception. They still might not fit within the exception. The state, in other words, might not be able to invoke this
Well,
exception.
sure, if you had an audit that was aimed more at, like, let's say, quality assurance,
Yes.
then maybe it wouldn't fit within the exception. But if you have an audit that is aimed at verifying public expenditures, that's law enforcement, that's a criminal
As
investigative
long as it's not
technique, and it
interfering with the
fits.
investigation. In other words, if it was already public information, you can't take a position that's going to interfere.
Yes, if it
Thank
was public, it wouldn't
Thank you,
interfere.
Mr. Lang.
Thank
Ms.
you, Your
Neidl?
Honors.
Thank you. Just to address subpart 1, courts require that there be an ongoing, pending, or foreseeable investigation. The state would say that every audit is an investigation. That on its face is ridiculous. An audit is not necessarily an investigation. An audit could be part of an investigation, but the audit's here, and we have to look at the record. These are not investigations. They could lead to an investigation. None of these audits have, though. The comptrollers have. That's a different case. With respect to subpart 4, that covers criminal investigative procedures. These are not criminal. They weren't drafted by an agency with criminal enforcement function. They were compiled by SED, not as part of its criminal, or not part of its criminal enforcement function. They simply do not fall under either prong of the statute. And now, if I could just talk about attorney's fees, it's an
Please.
important issue.
Yes.
In many cases, lower court cases have found that if documents are produced only as a result of litigation, then the petitioner has substantially prevailed. If you look at FOIA, when defining substantially prevailed, it includes where a petitioner gets an order in his or her favor. It also includes where the agency changes its position as a result of the litigation. That's what happened here. There's no question about it, that the
If you
appeal...
substantially prevailed, do we still have to send this back to the lower court to exercise its discretion as to whether and how much to grant?
In terms of how much to grant, I would say yes. In terms of whether it should exercise its discretion, I would submit that this court should hold it would be an abuse of discretion under the circumstances of this case not to award attorney's fees. Where suit was brought, as where an appeal was denied, all documents were withheld, and they were produced only after.
Was the appeal
litigation.
denied, or did they just fail to respond to it?
It was constructively denied. They did fail to respond to it.
Thank you.
Thank you.